hear you. Yes, ma'am.
Morning, ma'am. I can hear you.
Okay, it is now 10 o'clock and
And out of the stillness, a rush of energy is heard.
okay, can I ask that we all mute ourselves and only unmute if you want to ask a question or to say something? Can we please mute ourselves? Thank you for joining today's session. Thank you for joining today's session. Okay.
The top stories on Blitz this hour. The battle for semi-finals continues at Roland Garros. Victories for France and Spain as Euro 2020.
Students, can you hear me now? I am trying to mute all of you because some of you have not muted ourselves and it's a bit destructive. Can I please ask that we all mute ourselves in order for us to hear each other properly? Okay, thank you, students. Today's session is a repeat of last week's session, which due to technical issues ended abruptly. This is going to be it's a repeat, but it's the first section of our ongoing sessions, which we'll be covering for our PVL 2601 for family law. Today, we are going to talk about the legal requirements for a civil marriage. But how I want this session to be, I want this session not just to be me giving you a lecture, but I want it to be a question and answer session whereby I'll be asking you questions, and also in turn, you guys need to ask questions so that we have an interactive session. My name, those who were not with us last week, my name is Ntabisa Munaring, and I am one of the family law lecturers. Okay, today's session, we are going to start with the definition of a civil marriage. Can just one of you explain to us what do we mean when we say spouses are in a civil marriage? Hello, students. Can you hear me, students? Can you confirm that you heard my question?
Yes, we did.
Okay,
Yes.
can just
Yes, ma'am.
one of
And there are
you?
hands up.
Okay, can we give Mandisa Precious Radebe? Can you explain to us when we talk about a civil marriage, what are we talking about?
Thank you, ma'am, and morning to the fellow classmates. Okay, according to me, when we're speaking about civil marriage, it is a marriage that's an agreement voluntarily between a woman and a man. It's always between a woman and a man. So that's, according to me, that's a definition of civil marriage.
Okay. When you say between and a man, this one somebody else can answer. Does it mean that people of the same sex cannot enter into a civil marriage? Bearing in mind that people or couples who are in a same-sex relationship, that relationship is now legally recognized. So can people or can lovers who are of the same sex also enter into a civil marriage? Senzo, do you want to answer that?
Yes, ma'am. Thank you. Good morning, and good morning, everyone else. I think it means it's a marriage agreement between a man and a woman, and a man is only allowed to take one partner or to be married to that one particular woman. And then when it comes to the marriage of same sex, I think it then changes to a civil union marriage. Yeah, that's what I think. Thank you.
Okay, you are correct. A civil marriage it's a marriage that can only be entered into by spouses who are of the opposite sex, meaning it has to be entered into by a man and a woman. And then secondly, and most importantly, it cannot be entered by more than two people. We are all, okay, I am assuming that we are all aware that in South Africa, we have a polygamy marriage, which is also legally recognized. But unfortunately for civil marriages, civil marriage, it is monogamous, meaning it can only be entered by two people and two people of the opposite sex. Now, my question is, since I have made you aware that polygamy is not allowed in a civil marriage, can one of you explain to me or tell us what happens in a situation where, let's say, the wife decides that, you know what, I am going to leave my husband and I'm going to enter into another form of marriage with somebody else without divorcing my spouse. In other words, they are still legally married, but they are separating. Do you think that because this wife is still in an existing civil marriage, but she went and entered into another marriage with somebody else, what do you think the status of this civil marriage is going to be if the parties are no longer living together and one spouse is now living with somebody else and is married to that other person? Okay, Queen Ntie.
Hello, everybody. I don't think it will be possible to get married to somebody else while you're still married. You are in a civil marriage, because I mean you're already married by law. So, what is this? So you cannot go out. You are separated. The status of the marriage will be separated. It cannot be divorced because you are not divorced or whatever. So we're still married.
Okay, thank you so much for that. Yes, you are correct. As we've said, as long as there is an existing civil marriage, you cannot marry somebody else. So that subsequent marriage will not be recognized because only the civil marriage will be the one recognized. Now I want us to move on to the requirements of a civil marriage. Can one of you just tell us maybe what is the first requirement to enter into a legally recognized civil marriage? What is it that is what is it that it is required in terms of the law? Offense.
Can you hear me?
Yes, we can hear you.
The parties must have the capacity to act.
Okay, thank you for that. Can somebody expand on that? When you say capacity to act, or let me ask this way. Under what circumstances can it be said that certain persons or certain people or certain prospective spouses do not have the capacity to enter into a civil marriage? Can you mention, for example, can somebody just maybe mention one, the other one will mention the other one, circumstances under which it can be said that the person lacked the capacity to enter into a civil marriage? Can we have Amanda Hlengiwe? Hello, Amanda, can you hear us?
Yes, I can.
Okay. Yeah, you can answer.
Somebody who's I'm sorry, somebody who's underage or somebody who's mentally unstable.
Okay, you've mentioned two things. Now we are going to talk about them separately, but let me just hear what others are saying. Joanne Rakul, sorry for not properly announcing. I think it's your surname or your middle name. I'm sorry about that. Joanne, can you hear me?
So my understanding is capacity to act or lack of capacity to act is if a person is mentally unstable.
Mm-hmm.
If they're suffering, for instance, from mental condition or they're underage, or you also have an interim mental instability where it gives them a certain gap where they can't act.
Okay, thank you about that. Okay, if you have a look at your textbook, it talks about, there's 3 important factors. First, it talks about the prodigal. Those are persons who are unable to manage their own affairs. So the question now is, can a prodigal enter into a civil marriage? And this is something that was adjudicated in the case of Biner versus Biner Curator, where it was said that the fact that a person is a prodigal, that on itself does not necessarily mean that they lack the capacity to enter into a civil marriage. So what needs to be determined is, has the person been placed under curators, and has the person been either declared as a prodigal or has been placed as a prodigal? Because if they have been declared as a prodigal, then it means that they are unable to enter into a civil marriage. But if they have just been placed as a prodigal, then it means they can enter into a civil marriage. And the test to determine is, does that person have the capacity to enter into a civil marriage in spite of the fact that they are unable to manage their own affairs? So that is where, in terms of Biner versus Biner Curator, that is the important principle, or that is the important information that you must know. And then secondly, the mental illness. When it comes to mental illness, it is important to note that just because somebody has been declared that they are mentally not well, it does not necessarily mean that they are unable to enter into a civil marriage. So there is a test that needs to be determined, and that is, firstly, can the person understand the nature and consequence of a civil marriage? And then secondly, at the time of entering into the civil marriage, do they understand what they are getting themselves into? Can they make a rational judgment at the time? So these are the 2 factors that you need that needs to be determined in order to determine whether the prospective spouse who is mentally ill, whether they can enter into a civil marriage or they cannot enter into a civil marriage. And thirdly, and most importantly, minors. When it comes to minors, that is minor children, firstly, age, it is important. You need to understand that minor children who are between the age of 7 years and 18 years, they have limited capacity. And that means there are certain contractual agreements, including a civil marriage, that they can enter into. But there are requirements, one of which, or the most important one, is consent. So when it comes to minor children, you need to understand that if a minor child wants to get married, a minor child between the age of 7 years and 7 years and 18 years, they must firstly get consent from their parents. And when you talk about their parents, you need to understand the difference between the consent that they will obtain from married parents and the consent that they can obtain from unmarried parents. With unmarried parents, you need to determine whether both the mother and the father have guardianship. If the mother alone has guardianship but the father does not have guardianship, then the mother alone can give the consent. And also, when it comes to that, the consent or the marriage, the prospective civil marriage, has to be in the best interest of the minor child. If the parents are unwilling, or before I go that, apologies for that. If the minor child does not have parents who can grant the consent. The next person to grant the consent is the legal guardians. The legal guardians are in a way placed in the same position as the parents, and they can grant the consent or refuse the consent for the minor child to get married. Before I continue, Nkosana, I see your hand is up. Nkosana
Yes,
Tuluva.
thank you, lecturer. Can you hear me?
Yes, I can hear you.
Good morning, how are you?
We are okay, thank you.
Okay, ma'am, maybe just before you proceed further, I just wanted you to give me some clarity on the principle of lucidum interval in a case whereby somebody is mentally ill. Because I know at times you might get a person who's within the age of maturity that can be able to conclude the marriage, the person who's having the capacity. So I know the issue of the capacity, it's the one which is in question when it comes to the lucidum, because I know if we are in that stage, it's somebody who might be sick and then at some point regain the conscious. And then how do you then make a distinction that at that particular time when that person was concluding to that marriage, that particular person was sane or not sane? I think that's where that principle lies. So I just need your clarity in relation as to how do then now courts evaluate whether this person was sane at the time. So I think, yeah, that is my question, ma'am. If you can assist me, I'd really appreciate it.
Okay, for the courts to determine that, they will need expert evidence or expert reports, and only medical practitioners who specialize in mental health are the ones to determine whether at that time this Mr. Ndlovu, who was getting married and let's say a year before had been declared temporary insane, was he now in the mental state to enter into a civil marriage? Did he really understand at the time? And also when the marriage is concluded, you know, when the priest or the marriage officer is asking the prescribe, is doing like the prescribed formalities, will you so and so take this into in? So when he talks at the time, the kind of answers he's giving, his behavior and all of that, those are the things which are used to determine whether was this person at the time of entering into this marriage, did he really understand? And also maybe before entering into that marriage, the following weeks, how was his behavior? Because I'm assuming that we are all here not specialists in mental health, so we will not be able to really say for sure whether this person did they have the mental capacity to understand or not because of their mental condition. But those who specialize in mental health will be of much use to determine if indeed this prospective or spouse or this spouse understood what they were getting themselves into.
No, yes, ma'am, I understand your clarity in relation, but I'm raising this question on the basis that mental ill person is one of the requirements that a marriage cannot be concluded. That so now that's what the textbook is saying. But now, as we are explaining the principle of lucidum, an insane person reaching that state of lucidum can be sane, can be insane. So at that particular time when he's sane, so the marriage might be maybe all the requirements, let me ask, all the requirements have been met, that person's age is having the capacity, and then every process it was followed to the latter. So does that mean that that marriage at that particular time is
valid.
Yes, yes.
Yes, yes.
Oh.
If at the time of entering into the marriage he completed all or he fulfilled all the requirements and he had the capacity and he
Hello.
Ma'am, we cannot hear you.
She's gone again.
Okay, no, I'm not gone, I'm here. Okay, I was saying, at the time when the spouse enters into a marriage and he was sane and he fulfilled all the requirements, then the civil marriage will be recognized.
Okay, okay, no. Okay, ma'am. Thank you.
Okay. Nkosana, can I ask you to remove your hand so that I don't think you want to ask another question? Okay. We're still talking about the minor children. So with the minor children, the parents and the legal guardian must give consent. So a minor child, they can't just on their own decide that they will go and get married. If the parents or the legal guardian are unable or refuse to grant, or are unable to give the consent, the Minister of Home Affairs can't grant that consent. But it is important to note that the Minister of Home Affairs cannot grant the consent if the parents or the legal guardians have refused to grant the consent. The Minister of Home Affairs can only grant the consent if the minor child, there are no parents or there is no legal guardian to grant this consent. And the consent can only be granted if it is in the best interest of the minor child. If the minor child cannot get the consent from the Minister of Home Affairs, the minor child can approach the presiding officer of the Children's Court. The presiding officer of the Children's Court must only grant the consent if it is in the best interest of the minor child. If the minor child cannot get the consent from the parents, legal guardian, or from Minister of Home Affairs, or from the presiding officer of the Children's Court, the minor child can bring a High Court application to request the consent. But what the minor or the children cannot do is to approach the High Court without firstly going to the presiding officer. Only if the presiding officer of the Children's Court refuses the consent can now the minor children can now bring a High Court application. Katleho Matibedi, I see your hands is up. Katleho.
Yes, my hand is up. Thank you. I just want to ask, man, it seems like it's a lot of work for a minor to go through all these things. And I'm trying to think of a case of why would a child want to go through all these lengths to get married? So was there a case that happened that led to all these requirements happening? Why? It's just a lot of work for somebody to want to get married, to go through those extents. So
No.
there must have been a reason why these laws were created.
Is because on the basis that they are children. Remember, from birth up until you reach the age of 18 years, you've got limited capacity. So minor children cannot just be allowed to go and get married. So, and then remember, they're also still under the guardianship of the parents or the legal guardians. So the legal guardians or the parents must consent because the marriage must be in the best interest of the minor children. Minor children, by virtue of being children, they don't have, I don't want to say they don't have reasonable capacity, but they are not as matured as adults. And a civil marriage is it's a contract, it has legal implications. So it is very important that before they can be allowed to enter into that, there is an adult, there is a guardian who is there to make sure that if they enter into a civil marriage, that is in their best interest. Do you understand?
I understand, but I still don't see what case would it be for a child to be married. Why would it be in their best interest? Why can't they just have a law that says you can only get married after 18? So before 18, you are a child, and you will not be granted the privilege to get married.
Okay, in a way, you can say it is discriminatory against children, because what if we have a 16-year-old boy, a girl child who is matured and has a reasonable capacity of 30 years, and they feel that they are ready to get married? You see? So the law can just take away that right, but at least there are restrictions to say you can't just get married until we are sure that this is in your best interest.
I will converse that with then the age of voting then. So if you are immature to vote, but you are mature enough to put yourself in such a contract, it's baffling for me then.
Yeah. Okay, let's give others a... Okay.
So basically, you also need to understand that there's some cultures and religions that require for a female to get married at a certain age, which is not necessarily acceptable within the constitution. Therefore, this law is there for such situations, or the way I see it, is to allow these type of cultural groups to participate within their culture, which is also a constitutional right. Also, if you look at, for instance, when it comes to the Indian community, if a female has to fall pregnant out of wedlock, it is it's not excusable for her not to marry the person or the man that has impregnated her. Therefore, if she is under the required age of the law, her parents can still seek assistance via the court for permission, or give permission as the parent, for her to get married and enter into that legal contract.
Thank you, Joanne. Let's hear others. Naima, sorry for pronouncing your name wrong. Naima, can you hear us? Okay, Naima. Okay, let's move along. Alice Raisecha.
Thank you, ma'am.
Alice,
Yeah,
yes,
I just wanted to add on the last speaker that I have spoken to say, the last speaker who was saying, why would a child go through so much to, like, to be not to get married or to get married? Like the last speaker who mentioned culture. Remember, we've got things like ukutwala, wherein children are imposed to get married. So if you can check the steps that ma'am went through, from presiding officer to high court, if a child was imposed to get married, somewhere, somehow, someone is going to be able to pick up, or no, this was imposed, is not by choice. So all these things, they were done to protect a child, because a child is someone that we all believe that for them to grow up, they need protection. So if they can just be one law that says, no, you mustn't get married, and then you get kids that are allowed to do, I think it's a customary marriage before they can reach a major stage, wherein the parents have to be involved. So all these things, I think, in my opinion, they are done to protect the child, because the child is one person that I think is very vulnerable. So until they reach high court, maybe they can realize that, okay, this child was part of ukutwala, maybe she's abused, she's been done that, and then all that, I believe, is just for the protection of the child. Thank you.
Okay, thank you. We are going to have a last person on this one so that we can move on. Can we have Zimbini September? Zimbini, can you hear us?
Yes, I can hear you. Thank you so much, lecturer and fellow student. I'm almost covered because Well, I wanted to respond to the gentleman's question about the child. I suppose the Constitution is there to cover and protect the children. Because when the case comes up, they have something to rely on. The Constitution is there to protect. There should be something that is there when there is a problem. So the Constitution is there to protect. I'm almost covered, ma'am. Thank you so much.
Okay, thank you.
Sorry, ma'am. Sorry, I know you
Okay,
said it's the
who's
last one.
speaking?
It's
Okay, who's
Neo.
speaking?
It's
Okay.
Neo. Sorry, I raised my hand, but I see you're moving on. Just
Okay.
I wanted to know, I think also part of the initial speaker's question was whether there's case law on this. That's all I want to know. Is there a case law on this particular matter?
Okay, so far in the textbook, there is none, but what I can do for you guys, I can go and research, and if there is indeed case law supporting this, we can, I will put it on the thing, on the my UNISA thing, and then we'll just make an announcement regarding, what is it? Yeah, this. So please give me an opportunity to go and do a research regarding this, finding the case law, if we do have case law or a precedent confirming that everything that we've just said now.
Okay, thank you.
Okay. Okay, now I want us to move on to consensus agreement. When we started, one of the students said a civil marriage is an agreement. So my question to you is, under what circumstances can it be said that the civil marriage is void or is voidable because it lacked consensus, it lacked agreement? Can anybody or four of you just tell us what are the circumstances that can be said that the parties lacked a consensus to enter into a civil marriage? Can we get Bransby Shiba? Bransby Shiba,
Yes.
can you hear us? Yes.
Yes. I'm going straight to the age. Below the age of 15, it will be considered null and void. Yes.
Okay, below the age of 15 for which gender?
Yes.
Okay. Remember, when it comes to minor children and the age, there's two separate ages for the boy child and for the girl children. For the girl children, let me just confirm from my notes. A girl child is from the age of 15 and a boy child from the age of 18 years. So my question is this: a boy child below the age of 18 years and a girl below the 15 years may not get married without the written consent of the Minister of Home Affairs. So my question to you is, do you see anything problematic with this statement? A boy child below the age of 18 years and a girl child below the age of 15 years may not get married without the consent of the Minister of Home Affairs. Do you think this is fair? Do you think, is there anything wrong with how the law treats the girl child and the boy child?
Hello?
Hello, who's speaking? Naima?
No, it's Neo.
Oh, okay.
Sorry, I'm trying to understand the question. So are you saying that are we speaking about discrimination now?
No, I was just asking in passing if I can say it that way, because remember, in terms of the law, a girl child before the age of 15 years, but when it comes to boy children, it is not 15 years, it is 18 years.
Isn't it due to the scientific basis of maturity? the fact that girls mature before boys and therefore would then be better suited to make such decisions before boys?
Yeah, one can argue that, but one can also argue that taking into account that we now live in a constitutional era, maybe there's a bit of unfairness that why are girls allowed to at least get married at an earlier age, but with boys, it must be like 18 years. I understand, but that is just something just to think about.
Is it something we would be asked to ponder upon, or
no?
Okay,
no.
all right.
Because I wanted to say, for the purpose of the course, you just need to know the age difference, and then that's it.
Okay, thank you.
Okay. Anybody else besides the agreement? Who do we have? Naima? Naima? Okay, Naima is
May I fill
gone.
in, ma'am?
Okay, who's speaking now?
It's Nkosana.
Oh, Nkosana, okay.
Yes, ma'am. I think I just want to augment on this issue that you were discussing about now, about the fairness part in relation to the age of maturity. That the girl is supposed to be 15, whilst on the side of the boy is supposed to be 18. So I think you've explained it quite correctly, because of we are living in a democratic state, and then there's also we are also covered by the Bill of Rights that says that everyone before the law, we are all equal before the law. So I think it is prejudicial to the male side, because when you go to that to the basis of the law, Bill of Rights, so I think the males are being discriminated on the basis of the age. So another thing that I wanted to ask, ma'am, if we are to make an argument, there is a question of that nature which is being asked, you are giving your own legal explanation. Would you be penalized for disagreeing with whatever the law, case law, that it has been adopted, maybe to a particular court?
Okay. When you are asked a question in the exam, firstly, just have a
Yes,
look at what the question says, because there are certain questions which want a specific answer. But when it comes to arguments and everything, that will be more relevant when you are writing like an essay or a thesis, whereby you are also asking, okay, give your own personal opinion or give your own argument. That is when then you can argue the discriminatory or not. But for the purpose of this course and to make sure that you pass, please have a look at what the question is asking, and answer specifically what is being asked. Even if, let's say, you can see, but you know what, this is unfair. Remember, there will come a time whereby you'll be given an opportunity to state whether something is fair or not, but please to make sure that we pass, because at the end of the day, I guess we all want to pass, we all want to graduate. So we have to make sure that we answer what is being asked, and then when an opportunity comes to, when an opportunity arises to discuss certain things, that is when we are going to, that is when you're going to say what is it that you want to say. Do I make sense? Nkosana, is Nkosana, ne? Hello?
I got disconnected, so I just recently joined, so I didn't get most of your answer, but it's fine.
Okay, yeah. No, it's fine. Okay, when it comes to consensus, the agreement, firstly, both parties must have the intention to enter into a civil marriage with each other. This is very, very important, that they must not just agree that you are going to get married, they must have the intention to enter into a civil marriage. As we'll be going with the course, we are going to also learn about other types of marriages in South Africa which are legally recognized or which are partially recognized. But for civil marriage, they must have the intention to enter into a civil marriage. Circumstances where the civil marriage may be declared void, first is when there is a mistake. A party thinks that he or she is getting married to so and so, but it turns out the identity, they're getting married to the person whose identity they're not even aware of. That is a mistake. A mistake, I can say, in a way, it really happens because we know that a civil marriage is something that has to happen publicly. There must be witnesses. So the identity of the person, when you get married, you will know that person. But should it happen that you enter into a civil marriage and then you thought you were marrying John, but you ended up married Tabang, and it was a genuinely mistake, then that will lead to avoidable marriage. The second one is misrepresentation. Sometimes it happens that people prospective spouses misrepresent themselves. For example, a person or a prospective spouse gives you the impression that they can have children, and you enter into that marriage because you want to start a family with that person, and later on you realize that, you know what, I was misled. So that can lead to a avoidable mistake, avoidable marriage, because you were misrepresented. Or if the lady is pregnant by another man and they did not disclose, they actually lied to their prospective husband and said, you are the father, when they knew the truth. And the other circumstance is when a prospective spouse is in an unregistered customary marriage and they have not dissolved, they have not legally dissolved their customary marriage. Unregistered customary marriages are legally recognized, but because there is no marriage certificate, it's very difficult to know if your prospective spouse is married or not, unless if you maybe hear the information from female. So if you enter into a civil marriage and you later on found out that, you know what, my spouse is actually in an existing customary marriage, that again is misrepresentation and the civil marriage is voidable. The last one, okay.
So sorry, on that one, it's Noah speaking again.
Yeah.
So, on that one, like you said, because there's no marriage certificate or anything of that nature with regards to a customary marriage, especially an unregistered one, how then does the dissolution of said marriage legally come into force? For example, if you are now
Hi, Neo.
Oh, can you hear me?
No, you got disconnected there.
Oh,
you can ask again.
Okay, I was saying, how does the dissolution of such marriage take place formally or legally? Because, like you said, it is not registered. So, for example, if I have a partner who was previously in an unregistered party to an unregistered customary marriage, how would he then prove the dissolution of said marriage? For example, there are those who just simply disagree and say they don't, I don't want you anymore, and then I leave the marital home, does that constitute a dissolution of that marriage? What are the formal requirements for the dissolution of a unregistered customary marriage?
Okay, all marriages, including unregistered customary marriages, have to be dissolved at court, and there must be a divorce decree. If the customary marriage was validly entered into, it will remain in existence until it has been terminated by the court of law. So to prove that...
If it's not registered, how do we then get a decree of divorce if we never went to court to get any certificate?
Okay, you bring a high court application and you have to prove the existence of the marriage. Once you prove the existence of the marriage, then the court will dissolve the marriage. Okay, we will get an opportunity, a time where we will be discussing customary marriages in detail, and then you will understand how customary marriage work and how customary marriage can be dissolved. But what you must know is an unregistered customary marriage remains valid until it has been terminated by a court. And a customary marriage and a civil marriage cannot coexist. So if you are in a civil marriage and your spouse later on just leaves you and enters into an unregistered customary marriage, that unregistered customary marriage is going to be null and void. So if you get married and your spouse does not disclose that I am in an existing unregistered customary marriage, but I've just separated with my spouse, in a way that is misrepresentation, because a spouse enters into a civil marriage thinking that both of us are single and can enter and have the capacity and can enter into a civil marriage, only to find out that your spouse is actually still married to somebody else.
Okay, thank you.
Understand. Okay, I'm looking at the time, so I see your hands, but I just want to proceed because we still need to talk about the prohibited degrees of relationship, and we need to talk about the prescribed formalities of entering into a civil marriage. Yeah? Okay, we spoke about misrepresentation, and that one is duress. If somebody is forced to enter into a civil marriage under duress, the civil marriage is going to be voidable. And the last one is undue influence. If a prospective spouse or if a party enters into a civil marriage under undue influence, the marriage is going to be voidable. Now I want to talk about the degrees of the prohibited degrees of relationships. Yeah? There are two important concepts that you must know, and please, this you must know. And firstly, that is consanguinity, and secondly is affinity. Consanguinity refers to parties who are related to each other through blood. They have blood relationship which was created by birth. And there is two things that needs to be determined. Firstly, there is the direct line that is, from the parents to the children to the grandparents, and there is the collateral line that is between the siblings, the nephews, and the nieces. These persons who fall under these factors or under this category may not get married to each other. A parent and a child cannot get married to each other. Grandparents and their grandchildren cannot get married to each other. Siblings cannot get married to each other. And then we've got affinity, which talks about the relationship that comes between persons by due of them being married to each other, and like you are married to a spouse and there is a blood relationship between your spouse and his family members. So under a direct line, parents-in-law and their spouses, stepchildren may not get married to each other. And then a sister-in-law and a brother-in-law may not get married to each other. I see Naima has been raising his hands for a while. Naima? Okay. Nonhlanhla, have you raised your hand? Nonhlanhla?
Yeah, hand is up. I just wanted you earlier on to just explain the concept of voidable, because I know there is void as well, and I've been struggling to understand the difference between the two. Yes.
Okay, void, it means a marriage that we can say never in existence. And then voidable is a marriage that can be said did not exist or it exists. You can bring a high court application for the court to determine whether this marriage is going to be declared as a valid civil marriage or is going to be declared as null and void. So it is not automatically regarded as if it never existed at all. But a void marriage is the one that we are going to say automatically it does not exist. Let me just give an example, a common example, especially in the Black community. When a spouse who is in an existing customary marriage enters into another marriage, but a civil marriage with somebody else, the civil marriage will automatically be void, even if they went to Home Affairs, got their marriage certificate, they had the ceremony and all of that, because there was an existing customary marriage. But for avoidable, if let's say there was a mistake when you entered into a marriage with this party, but there is still an opportunity to declare that marriage valid, then that is where the difference is. One is automatically does not exist. The other one, it can be declared that it exists, or it can be declared void. So it does not automatically mean it does not exist. Do you understand?
Yes, thank you.
Okay. Big brain, Moloi. Big brain, Moloi. Okay. Alice, have you raised your hand again?
Yes, I've raised my hand again, ma'am.
Okay.
I wanted to ask Jorge, if ever, in terms of misrepresentation, if I married someone who told me or he's got money and he doesn't have, do I have a case? Because I married that person thinking or his money, whereas he's broke.
No, you don't have a case there. No, you don't have a case there. Okay, Joanne, did you raise your hand again? Hello, Joanne? Okay. Who's speaking? Neo, did you raise your hand again?
Yes, I did. Sorry,
Okay.
with regards to prohibited degrees of relationship, just I want to understand. So okay, my understanding is consanguinity refers to blood relation through birth, right?
Yes.
This involves the parents, grandparents, and siblings, right? In the direct line, and aunts, uncles, nephews, and nieces in the collateral line. And then affinity.
Okay, the siblings. Okay,
yes?
wait. No, the siblings fall under the collateral line, not in the
They
direct
fall
line.
under collateral.
Yes.
Okay. Why is that? I mean, because they didn't give birth. Okay. No. Never mind. Okay.
Understand.
So okay. All right. That makes sense. So nephews, nieces, siblings, aunts, uncles, those would fall under the collateral line, but consanguinity still, right?
Yes.
Okay. And then with regards to affinity, my understanding is that it's so okay, affinity confuses me a bit because you said it's relation through marriage, but you also mentioned blood relation. Can you maybe clarify that? And as you clarify that, could you also maybe just also insert where adopted children, where they would fall under, and step parents.
Okay. With affinity, it's comes through marriage and the blood related relatives or family members of your spouse. For example, you as Neo cannot marry your brother not your brother-in-law, your father-in-law, because your father-in-law is the parent of your husband. Do you understand? So that is why, and that is in the direct line. So you cannot marry your parent-in-law or your spouse's children. In other words, your stepchildren. And then the collateral line talks about your sister-in-law and your brother-in-law. So you cannot get married.
So parents-in-law and spouse's children is the direct line.
Direct line, yes.
Okay, all right.
And the collateral line is the sister-in-law and brother-in-law.
Okay.
So it's the same like under consanguinity, but this time, because it came through marriage, instead of saying my sibling, you're going to say my siblings-in-law. Yes.
Okay. And then with regards to adopted children and step parents or stepchildren?
Okay. Adopted children, firstly, it's important to understand that a child who has been legally adopted is regarded as if you have given birth to that child. So the same rules will still apply. And then adopted, you said adopted children, stepchildren, you may not get married to your spouse's children. In other words, you cannot get married to your stepchildren.
Okay, so what I think my question is then, your adopted children, since they are regarded as to be legally born of you, right?
Yes.
They would fall under consanguinity. Is that correct? Okay.
Yes,
And then stepchildren, do they fall under affinity or?
Affinity, yes.
Okay,
Affinity,
all right.
and then under direct line.
Direct affinity under direct line. Okay,
Direct
thank
line,
you.
yes.
Thank you very much.
Okay, there are 4 basic rules to determine whether persons are within the prohibited degrees of relationship. The first one is blood relatives in the direct line may not marry each other. For example, one cannot marry their ancestors or descendants. Secondly, blood relatives in the collateral line may not marry each other if either of them is related to their common ancestor within the first degree. That means one cannot marry their sibling, their children, grandchildren, nephews, or nieces. Rule number 3, persons related to each other by affinity in the direct line may not marry each other. For example, one cannot marry your ex-spouse's blood relatives in the direct line. That is the parents-in-law, and then that is the children, your ex's children, stepchildren. And rule number 4, persons related to each other by affinity in the collateral line are allowed to marry each other. One can marry their ex-spouse's blood relatives in the collateral line, cousins, nephews, and all of that. Yeah? I don't know. Can you guys see this document that I'm talking about?
No.
Because I can make it turn in available for all of you to have access to it. I had shared it because from my side it says it is shared. So I'm not sure why
It
it's
only
not
shows us the
visible.
first page, and it's been stuck on the first page. If you can share it with
Okay.
us, I'd appreciate that. Sorry, ma'am. Can you please repeat that last rule? You said the ones that can marry. Can you just say that one slowly for us?
Okay. One can marry their ex-spouse blood relatives in the collateral line. For example, cousin, niece, nephew. So you can marry your spouses, but only if they're in the collateral line. If they're in the direct line, you may not get married to them.
So
Okay,
you can
I
marry
will
your
share this.
ex-husband's brother, basically.
Yeah, brother-in-law. Yeah, those who are in the collateral line.
So if I divorce
Cousin,
from
niece,
my husband, I can marry his brother after we're divorced.
yeah.
Okay. Thank you.
Okay, now the prescribed formalities. Ne?
As long as his brother is hot, then you can.
Okay, they prescribe formalities. Both parties must be personally be present when they get married. The marriage must be solemnized between 8 a.m. and 4 p.m. and in a religious building, public office, private house. But if a marriage, let's say the solemnization of the marriage happens at the beach or somewhere else, that civil marriage will still be legally recognized. So the fact that it did not take place in a building, that does not necessarily mean you did not comply with the formalities of entering into.
That's the Doe case. Ne?
Yes, that's the Doe case, the ex parte Doe. And then lastly, registration of civil marriages. Here it is important to note that the civil marriage must be registered, unlike a customary marriage, which is customary marriage, we'll talk about it in details later on, but customary marriages automatically are legally recognized without the marriage certificate. A civil marriage, the marriage must be registered, but non-registration of a civil marriage does not render the civil marriage void. The parties can still later on go to Home Affairs where there are marriage officer and get married. But if they get married, let's say by a marriage officer who is a priest, a bishop, they need to complete the marriage register, and the marriage officer has a legal responsibility to submit the document to Home Affairs. So sometimes happens in practice or in people's life that they will just leave everything to the marriage officer, everything to the priest or to the bishop, and later on realize that, you know what, we don't have a marriage certificate because we thought that the bishop or the marriage officer will do everything. It is important to note that although the marriage officer, especially the priest or somebody out of the Department of Home Affairs, if they together with the parties and the two witnesses, they complete the prescribed document, it is important that spouses also ensure that their marriage is registered at the Department of Home Affairs. Okay, before we conclude, let's just give others a chance to ask. Petile, Petile, can you hear us? Petile, okay,
Hello.
Petile can you hear us?
Yes, I can hear you. I'm sorry for taking long to respond. Morning, everyone. My question was based on the civil marriage, right? Say I meet somebody now, and then they're going through a divorce. It's not been finalized, and then I enter into a customary marriage with that person. Which marriage is valid?
Okay, the civil marriage is gonna be valid. It is important to know that a civil marriage remains in existence until it is terminated, divorce or death. So let's say you are on your way to the divorce court and you unfortunately have an accident. Your spouse will be regarded as the surviving spouse because the court has not yet terminated. Yes. So
basically, the customary marriage is
null and void. Yes. No, it's not. The customary marriage is not useless. What it is important is people need to finalize all their issues. If you are in a civil marriage and you are undergoing a divorce, finalize that before entering into another marriage. Because remember, a civil marriage cannot coexist with any other marriage. So the problem is not the law, it's people who are doing their own things.
Thank you. Thank you.
Okay, I can't see any hands. I don't know what happened to my spirit. Okay, I need to go to. Is there anybody who's still raising his hand?
Hello.
Yes, of course,
Hello. Okay,
yes,
my
of course,
screen
ma'am.
is no
It's
longer.
Nkosana.
Nkosana, okay.
Yes, ma'am, because I've been raising my hand, but it's fine. At least you've given me the opportunity. Look, ma'am, I know you've mentioned the marriages which fail to follow certain requirements, then they are set aside by the courts. And then one of the examples that you've made, it's about a mistake. So I'm taking cognizance to one of the, as a reference to the Martins versus Martins case, where a friend requested another friend to marry some body because of their residential issue. If that marriage becomes valid, then that particular person would become a resident of that particular country. I'm not sure. So now, ma'am, going now to the mistake, I just want you to give me any specific case where there was a case similar to those ones, but there was an error of person or error in negotiation, because there's something that is explained there, but I'm not seeing any specific case that is giving credence to such cases except for this one. That's question number one. That's question number one, ma'am. And then my question number two is this, ma'am. You said in another, one needs to also be mindful that there are prohibition in terms of the degrees and relationships. So the one that I'm more interested is the direct line, which is in relation by affinity, and the collateral line, because I feel that one, it's suppressing the customary marriage, because you often get people in customary marriages where a person like myself, I'm married to a certain family, and also my cousin would marry in that family. So I just want to check, ma'am, isn't that that direct line suppressing the customary principle? Thank you.
Firstly, on your first question about mistake, there is not too much case law with regard to mistakes, mainly because a compulsory requirement when entering into a civil marriage is that you must be personally present. So when you say, okay, there was a mistake, so what kind of mistake did you do? Unless you were under the impression that everything that is happening was just an engagement, and this person represented represented the brother of the spouse that you want to get married to. But even that one is going to be very difficult. So that is the reason why when it comes to mistake, it fairly happens that there will be a challenge based on mistake, because the two parties must be personally there when the marriage is solemnized. The second one is, can we put it aside for now, because we are going to talk about customary marriages in detail. So for now, when it comes to civil marriages, you must know that these are the prohibited degrees of relationship that can be entered into. And then when we talk about customary marriage, we are going to look at this and see if, okay, although civil marriage said this, does it also applies to customary marriage? So I don't want us to confuse it now. Yes, I know I'm the one who introduced the topic of customary marriage, because I found it to be very easy when giving examples, and also because customary marriage, it is something that is now common in South Africa, especially in the Black communities, and there is a bit of misinformation or a lack of correct information regarding, okay, if I'm in a customary marriage and in a civil marriage, can I do them together, and all of those things, understand? So when we talk about customary marriage, we are again still gonna touch on civil marriage, especially when we make examples, so that it's going to be easy for you as students to be able to understand the two types of marriages. Okay, now I'm going to give those who have never asked a question an opportunity. I see, who's this? Richard. Richard, can you hear us? Richard? Okay, I'm passing. Cynthia, is it the second time? Okay.
Yes, ma'am, I can hear you. This is Richard.
Oh, Richard, okay.
Morning, ma'am and colleagues. How are you?
We are okay, Richard.
Yes, ma'am. Will you please share that document on my UNISA? Because I can't seem to find it on Teams. So will you please share it on my UNISA?
Yes, I'm going to share it. Mona Tsirei, thank you, Richard. Mona Tsirei, Makanaka. Hello, Mona.
Yes. Greetings, everyone. I just wanted to ask something. For example, I just discovered that I have a brother, a long lost brother, and we share the same mother but different fathers. But I just found out that also my brother has a child, and then I happened to go into a relationship with the child of my brother, and we go into a civil marriage. Will that be valid or not?
Entering into a civil marriage with your no, that's not gonna be valid, because remember that will be your nephew.
Your nephew.
You cannot, yes, that's gonna be your nephew, because your brother, although it's a long lost, the fact that you share a mother, you are blood related, that on its own means the civil marriage is going to be null and void.
Okay. Thank you.
Student, thank you so much. I'm going to first. Who's speaking now? Okay, somebody is talking outside at the background, and they seem to be at work. Who's talking now?
Ma'am, I just want to ask on the previous question. So
who's
in that
talking,
situation,
Joanne?
It's Joanne. What happens to that marriage if it's already been solemnized and they have children?
Okay, which marriage are you talking about?
The one that the previous student just mentioned.
Oh, okay. Well, it's gonna be invalid if they're already children. Remember, it was a mistake from their side. A mistake in that the student can mute themselves. Okay, I'm gonna mute every. Okay, I'm going to mute every.
Hello. Am I the only one who can't hear anything?
Oh,
Professor, we can't hear you.
Maybe
I think she is on
She
mute.
muted herself instead of us.
Myself. Oh God.
Excuse. We can hear you now.
Student, please.
Can you hear me now?
Yes, we can.
Student?
Yes, we can.
Yes, we can. We can hear you.
Let me give another one. Okay, I see Nero. No, Mandisa, Bawinile, Pumzile. I see only 4 hands now. Can you hear me now?
Yes.
Yes.
Okay. Okay, let's wrap up. And I'm gonna wrap it up with 2 last questions. I wanted those who has not asked a question but has raised their hands. Who's me? Who's saying me?
Cynthia.
Okay. I'll give Cynthia, and somebody has just said Swongile. I can see Swongile's hand here. Okay, Cynthia, what did you want to say?
My question was regarding the affinity line, where I wanted to understand if people are like, if you married and then you both have children from maybe a previous marriage, the kids, are they direct or they are collateral? Like they stepsisters, stepbrothers? What's the relationship between
No,
them?
stepsisters and stepbrothers may get married to each other. Remember, the only relation they have is that their parents are just married to each other. Unless the only exception is maybe the parents legally adopt the children, but they may get married to each other. Okay, the last one, yeah. Okay, the last one is, I think he said Sharon. Is Sharon here? Sharon?
Pumzile.
Oh, is who? Pumzile?
Yes.
Okay. Okay.
Hello.
Yes,
Hi,
we are
everyone.
listening.
Yes. Can you hear me?
Yes, we can.
All right. Thank you so much. My name is Pumzile. I have a question. Can you please give me an example on the undue influence for the voidable marriage?
Undue influence.
Yes.
Okay. What example can we use for undue influence? Let's say, okay, this gonna be, I will say, an awkward example, but let's say you were told that you are dying now, and Mr. So and so is the only last person or the only person who's willing to enter into a civil marriage with you, and you were just influenced, and at the time you thought that maybe you are dying and you have this wish of entering into a civil marriage, and you just enter into that marriage because you were unduly influenced. Understand? That is just an example I would give, but also again, it is very difficult for one to bring a court application saying they were unduly influenced, mainly because when you get married, it's a public affair, and then there must be witnesses. So you must be able to prove that indeed you were unduly influenced, which is something that is extremely difficult.
Sorry, ma'am, I know you said you are leaving. Ne? I'm sorry.
Who's speaking?
It's
Who's
Neo.
speaking?
It's Neo.
Thank
I
you
know
so
I've
much.
spoken before. I just want to know if, you know, with a civil marriage, there should be two witnesses.
Yes.
If there is only one witness, what is that marriage said to be voidable or void, or what are the in terms of formal requirements? Now, I'm so sorry. It's because I've had this question for a long time.
Okay, there must be two witnesses. So if there's only one witness, it means the requirements were not fulfilled.
Does that render it void?
It renders it voidable, not necessarily void, because if a spouse can prove that all other requirements were met, then the marriage will not be said to be void.
Zero.
It's voidable.
So it's not void.
No, it's not void. It's voidable.
Okay. All right. Thank you.
Okay, thank you. This one is the last one. Yeah.
One last one. One last one from me.
I'll be next.
Yes, we are
Ma'am.
listening. Togoso, right?
Nkosana.
Yes, Nkosana.
Yes, ma'am. I think there was a question, very important question, that it was asked about the undue influence in a marriage. And I find it difficult to strike a balance when it comes to undue and cohesion. Because my belief is that when something is undue, it's when maybe somebody is threatening to kill you or to kill even your baby, and then induced you to is that duress, or is it a it's difficult for me to strike a balance when it comes.
That's
is it
duress.
duress? It's duress or undue influence?
No, that is gonna be duress, but the problem is, remember, there must be witnesses. There must be the marriage officer. So for you to say I got married under duress, it means all the other parties must have been one scheme. They must have been working together to force you to enter into a civil marriage, because you cannot say I was unduly influenced, maybe they held a gun, or not unduly, I got married under, yes, you can say I got married under duress, but you must be able to really prove that indeed I was told that if I don't get married, my family will be short and all of those things. And then it must be something that even the witnesses and maybe the marriage officer will not have been aware of, because it's something that happened at home, yes, but in public, you needed to act like I'm doing this thing and I'm voluntarily entering into this civil marriage.
Yes, let us assume, ma'am, you took a volution position that I'm not going to tell anyone because of the life of my kid is in danger. Should I not pursue with this marriage, then my child is going, I do not inform anyone. So you are having now that duty now to.
Hi, Nkosana. We can hear you. Can you guys hear Nkosana? Can't hear Nkosana anymore.
No, can't hear.
Can you hear me now?
Okay.
Can we pass? Can you hear me now?
Okay, yeah, but we get the gist of your question. So, if a spouse can prove that I entered into this marriage under duress, then yes. But remember, the marriage is gonna be voidable, and then they will just need to prove at court that they entered into a marriage under duress.
Oh, okay. Okay, thank you, ma'am.
Just last
Thank you,
question,
students.
please.
Thank you.
Okay, this is the last question. Who's speaking?
Mandisa, thank you for the opportunity.
Okay.
Coming back to the lady Monari, right? She said that she found out her parents were married. Her parents were basically married, and then there was a child born from the other relationship, outside relationship. What are they going to be? Are they going to become collateral blood relative under consanguinity or affinity?
Okay, repeat your question. I did not hear it. I had something blood related. Can you please repeat it?
Okay, I'm saying it's regarding Monari's question, the lady, right? She asked that if her parents were married, right, and then they later found out that the father had a child outside the relationship, what would that make Mona and the other sibling? Is it collateral under consanguinity or affinity?
No, it's going to be direct. Remember, there is blood relations between the child and the father. So it's going to be collaterally for the siblings, but for the wife, and it's going to be direct, because remember, the wife cannot get married to the stepchildren, and the siblings cannot get married to each other. The siblings are collateral.
She was asking if it's consanguinity or affinity, and it's
No, it's
consanguinity.
consanguinity. Yeah, it's consanguinity.
Under the direct line.
Yes.
Oh, thank
No,
you.
under collateral line. Siblings under collateral line.
Okay, thank you.
Okay. Thank you so much, student. I shall see you, I think, next week, because next week we have to do Unit 2, but we'll make an announcement.
Thank you, ma'am.
Please don't forget to
Don't forget to
attach.
upload for us.
No, I won't.
Thank you.
Bye.
Bye.
Hi guys.
Bye-bye. Bye-bye.
Angatkasa kubantume. Nje nisabuti. Hayi bonga tkasa kumeya. Play. Mpumi, akwazi ukubona ngathi umzini. Can't happen. This can't happen. You understand? In what's only for me? Ngikubona njani? Cha, angibi ngiyabuza indaba.